Good morning, everyone, and welcome to today's Lunch and Learn and the ADA webinar. Uh, just before we get started, I wanted to let everyone know a few of the basic accessibility features on Zoom. Uh, at the bottom of your screen, you'll see some audio settings where you can and other controls. If you need to ask your questions, you can either type it in the chat using the Alt plus Y button if you need to use keystrokes to open up the chat. You can also use the raised hand feature if you need to type or if you need to speak your questions out loud. There will be opportunities to ask questions during this webinar, and we will, if you do need to speak your question, we will announce that we are going to allow you to unmute your microphone, and if you need to if you need to communicate via sign language, please let us know in the chat. We will promote you to panelist temporarily so you can also turn on your camera and converse with our ASL interpreter. Thank you.
Okay, thank you so much, Gabriel. This is Jan Garrett speaking, and welcome to Your Rights as a Person with a Disability under the ADA in Employment, a deeper dive. So I am the Deputy Director of ADA Programs for the Pacific ADA Center, and I'm very pleased and honored to be joined today by two colleagues. So I will toss it over to Pat first to introduce herself, and then to JJ.
All right, thanks, Jan. My name is Pat Swartz. I am the lead technical assistance specialist for the Pacific ADA Center. And JJ?
Good afternoon, everyone. JJ Rico. I'm the CEO for Disability Rights Arizona. We're the designated protection and advocacy agency in Arizona. And I am also a licensed Arizona attorney that's been practicing this area for the past 24 years.
Wonderful. Thank you so much. So a little bit about the Pacific ADA Center. We are part of the ADA National Network, and our mission is to provide resources, training, and support to improve awareness and understanding of the rights and responsibilities of everyone under the Americans with Disabilities Act. And on screen, sorry, is a map of the 10 regions of the ADA National Network. We represent Region 9 in the green states. So if you are from somewhere else in the country, you certainly can contact your ADA National Network Center and ask questions about employment or other aspects of the ADA. Next slide. So at the Pacific ADA Center, there are things that we do and things that we do not do. So we do provide confidential information and resources on the ADA by phone and email. We also provide resources and links to resources through email and through our website. We also provide referrals when necessary to other organizations that people need to be able to talk with, either for advocacy or other purposes. We provide training. This is an example of our training. We do a lot of training virtually, but sometimes in person. We have every year a conference, and we will be having our conference in March of 2026. It's a virtual conference. We hope all of you will be able to join us for that, March 10th and 11th. And we also have a very helpful website that we hope that you will explore at adapacific.org. We do not provide advocacy services. We do not provide legal advice. And we do not enforce any of the laws. The federal agencies typically enforce the laws, or lawyers that somebody might contact will enforce the laws. And we don't report anyone either to an enforcement agency. So what is considered employment discrimination under the ADA?
Hi, Jan. I wanted to interrupt really quick. If our captioner can please put the link to the stream text in the chat, uh, that would be great. Thank you.
Okay. We should hold on for one moment.
Yeah, just hold on one moment. We had a request for the stream text. Want to make sure that it's available. Perfect. One moment while I make this available to all of the audience. Okay, we have put a link to the stream text for anyone that needs to view the transcription record in an outside browser form. Please use the link that we just put in the chat. Thank you. I
Thank you very much.
apologize for the interruption.
No problem. Thank you. We want to make sure that everyone has access. It's important. So, in terms of who's covered by the ADA, what employers are covered by the ADA? So, all state and local government employers of any size are covered by the ADA, and then private employers that have 15 or more employees, and that can be part-time or full-time, as long as an employee works at least 20 weeks a year for an employer, any amount of hours over the course of 20 weeks in a year, then they are considered to be an employee for purposes of counting 15 or more employees. And note that your state laws may cover employers with a smaller number of employees than 15. So you should note that. Employment discrimination under ADA Title I is found when covered employers may discriminate against qualified applicants and employees when they fail to provide an equal employment opportunity. So that is kind of equal access to all the employment opportunities that they offer to what other people have available to them that do not have disabilities, or they fail to provide a reasonable accommodation to which the applicant or the employee with a disability is entitled. And we'll be talking more about reasonable accommodation. So this is generally what's considered employment discrimination under the ADA. So speaking of reasonable accommodation, who is it who can request a reasonable accommodation? Applicants for a job or employees who are already on the job can request a reasonable accommodation if they are a person with a disability, and we'll talk about the definition of disability in a moment briefly. So if the person is a person with a disability or has a record of a disability under the ADA definition of disability, if they are qualified to perform the essential functions of the job, if they disclose their disability or the employer somehow becomes aware of their disability, and if they request one or more reasonable accommodations from the employer. So the ADA definition of disability for purposes of reasonable accommodation is, the first section of it is a physical or mental impairment that substantially limits one or more major life activities. And impairments can include things like mental illness, epilepsy, HIV, cerebral palsy, cancer, autism, and many more possible impairments. If that impairment substantially limits a major life activity, major life activities can include things like seeing or hearing or breathing, or cognitive functioning, or other major bodily functions. And again, many more things can be considered major life activities. So if you meet the definition of disability for the first section of the definition, then you can meet it for purposes of reasonable accommodation. Also, if you have a record or a history of such an impairment, you can meet the definition of disability for purposes of reasonable accommodation. But many of you who know about the definition of disability know there is a third part that talks about being regarded as or perceived as having a disability or a physical or mental impairment. If you are regarded as having that physical or mental impairment, that protects you from employment discrimination generally, but you are not entitled to a reasonable accommodation if the only way that you fit the definition is through being regarded as or assumed to have a physical or mental impairment. Next. So being qualified is also an important part of this discussion. Employees and applicants are qualified if they have the skill, experience, education, and other job-related requirements. And then, if they meet those, they can, with or without a reasonable accommodation, perform the essential functions of that job or that position. And we'll talk about essential functions in a moment. But the job qualifications that the employer puts out there in terms of what they consider to be qualifications for that particular position cannot screen out people with disabilities. That is not allowed under ADA Title I. So, for example, requiring a driver's license in a job description when the only thing that's really required for the job is to be able to travel away from the job site, then that could be a screening device that would screen out people with disabilities who don't have driver's licenses, but could indeed use other methods of transportation when they need to travel away from the headquarters or job site for the job. Next slide. So, essential functions versus marginal functions. When you're looking at a job and you're determining is something essential or marginal, it's essential if it's the duties that are absolutely needed for the job and or the job actually exists to perform those functions. So an example could be a receptionist that answers phone calls and greets visitors. It could be someone who cleans the office, who needs to be able to perform that cleaning duty. There are many possible examples of what could be essential functions in a particular position. But marginal functions are things that are not necessarily needed to perform the job. And you might be able to trade these functions with other employees. So using that same receptionist example, a receptionist opening and distributing a mail to all employees may be a marginal function of their job because it doesn't involve greeting people and answering the phone, and other employees could possibly open and distribute the mail. So that's could be considered a marginal function under the job. Next slide. So applicants and employees who need reasonable accommodation must disclose their disability to the employer verbally or in writing. And there's no magic words to do this. You simply can say, I need something to help me do my job because I have a disability. Now, if you don't need an accommodation of any kind to do your job, you don't have to disclose anything about having a disability. Note that the employer can request more information or documentation if the person's disability and or the best accommodation is not obvious. But if it's obvious, then the employer should not be asking for more documentation. There are complicated rules about when you can ask for certain documentation, and we won't really be getting into that in this webinar, but you can certainly call your ADA National Network Center or your Disability Rights Center to get more information. Once an employer receives information about someone's disability, then they have to keep that information confidential. And that information also should not be used in any kind of performance evaluation of the employee. The employee's performance, with or without the accommodation, is what should be evaluated in a performance evaluation. Okay? So either the employer somehow knows and asks the employee, or the employee discloses their disability. And now I'm going to pass it over to my colleague Pat to talk a little bit about reasonable accommodation.
Okay, thank you, Jan. So, what is a reasonable accommodation? The definition is that it is any modification or adjustment to a job, an employment practice, or the work environment that allows a person with a disability to enjoy an equal employment opportunity. And you'll see this is a photograph of someone using a stand-up desk as a reasonable accommodation for their job. And so here are some examples. And again, there are so many examples. Here are just a few of ways to provide a reasonable accommodation. You could have a job reassignment or restructuring, modifying or getting equipment that a person might need, providing auxiliary aids and services, allowing use of service animals or emotional support animals, allowing use of paid or unpaid leave for treatment or service animal training, accessible workstations, modified work schedules or leaves of absence, modifying policies or procedures that include telework, changing when or how an essential function is performed, or reassignment to a vacant position. And that is usually as a last resort if no other accommodation works. And all of this takes place in an environment called the interactive process. So it's not an instant thing where somebody says, I want to bring my service animal to work, and it happens. It doesn't. There's a process to go through.
And Pat, thank you. I'm going to interrupt you. There is a question that kind of relates to the telework portion of it. And Ashley says, lately there has been a debate about employers making 100% in-person work as an essential function, even when the job doesn't require that. They may justify it by saying collaboration or public facing. But the past 5 years have shown that 100% in person is not necessary for many jobs. And so you can, be able to come in some of the time, and including her job as a counselor. She's saying, can you speak more on this topic, and what is the Pacific ADA Center's guidance about accommodating people for these reasons?
Well, I think Jan and I have talked about this. The answer is that it depends. And ultimately, the employer decides what the essential functions are. And although a therapist or a counselor experience may be that it is totally effective 100% of the time in telework, the employer may not agree. So it's part of the interactive process that determines what will hopefully work for both parties, but it is the employer's ultimate decision. Jan, what do you think?
Yeah, I mean, you certainly could raise your objections to coming into the office. Maybe you come in some of the time. Maybe it's important that you be face to face with your clients. I don't know what arguments you can make. It really depends on the job and depends on the situation. So I would certainly, try to make your arguments. And, if you feel like you really are being discriminated against by not being allowed to do some telework, then you can ask the EEOC for assistance. You can file a charge of discrimination with your state employment agency or the EEOC to say that you feel like you're experiencing discrimination. So it's a hard one to know, as they usually say in the federal the federal requirements. It depends, but certainly the amount of time, yeah, as you're saying, the amount of time spent performing the function, um, and the experience of others who have performed the function. But again, we can't really answer that definitively here. I don't know that we'll answer any questions definitively today, but certainly it's a good question to raise. Telework is something that gets asked for a lot. Um, Also, I know the question about reasonable accommodations are not limited to job function or programmatic. They can also be talking about the accessibility of the job location, and where you might be assigned to make sure that you have the accessible features that you need. Yes, that is true. Okay, so and then each request, yes, has to be assessed on a case-by-case basis. That's very important with employment-based, and really the ADA in general. Everything is individualized and needs to be assessed on a case-by-case basis. And that's part of the interactive process, as Pat was talking about. And I'll turn it back over to Pat now.
And Jan, did we answer this question? Susan Allen, if an employee was out on short-term disability for medical reasons, do they fall under these rights under the ADA? If so, and an employer does not allow the employee to come back to work based on clearance to perform duties, what can the employee do if they were terminated?
Well,
go ahead, Jan.
yeah, I was going to say again, this may be a more fact-specific discussion. If somebody's out on short-term disability, they may or may not fall under the ADA. Likely they do, but they may or may not. And generally, you do need to allow the employer to come back to work. You generally cannot require 100% clearance for somebody to come back to work and to perform the duties. But again, that's a very fact-specific discussion. So these fact-specific questions, it's really good to raise them. We appreciate you asking, but it may be something that we need to discuss with you more in a technical assistance call or in an email generally as well. So so thank you for the questions that are coming in, and if JJ has any different answers, he can feel free to chime in.
I'll jump in on the telework, and I think the person's question, or at least the way I read the person's question, was we've had 5 years of experience of telework being effective, and if the question is, hey, I've been doing it effectively, I've got good reviews over the last 5 years, I think that's information that can be used to support the continued accommodation, especially if that's something that's supported by a treating physician, someone that says it's related to your disability, a need for an accommodation. The employer still has to engage in the interactive process. So whether or not they set a policy saying everybody's got to come back to work, that you can set a policy as an employer, but you also need to always participate in the interactive process. And then you have to have that back and forth. And at least that would give you an opportunity to share how successful you were performing the functions of your job in a telework environment, and then they can articulate the reasons why, and then hopefully there's a meaningful discussion on either middle ground or continuing to telework. So I saw somebody else's question about a case-by-case basis. Yes, everything's a case-by-case basis. Everything should be individualized. So that's the other thing, having a blanket policy and saying no exceptions, again, in my opinion, is contrary to the ADA. ADA is an individualized inquiry, an individualized assessment. So that's my take on the telework. On the short-term disability, again, I don't want to get into any concrete specific scenarios, but I'll say one of the things that folks that are going out on leave should always also consider is the Family Medical Leave Act, because there are some job protections there. No, that's a little outside of our discussion here. But obviously, if there's a need to return with accommodations, to Jan's point, there should not be 100% or a certification that the person has no restrictions. And that's why the ADA was created, to have that balance, to be able to meet the essential functions of the job with or without reasonable accommodations. So I'll stop there. I know I'll have some scenarios maybe where we can have some more discussion, but I really appreciate everybody's question.
Yeah, thank
Right.
you so much, JJ. And again, Ashley, like JJ was saying, if the employer is saying it's an undue hardship, which is the defense that they can raise, they can't just sort of just say that and say, well, it's our blanket policy and it's an undue hardship for everyone not to be in the office. They do have to be able to show why it's an undue hardship. So yes, that's important. Okay. So
Okay, and so
I know we have some people with raised hands as well.
Okay. Candace, I see you there. I'm going to give you the ability to temporarily unmute yourself. Okay, you can unmute yourself and ask your question.
I'm sorry, I think I have the hand raised by accident.
Okay, that's fine. Anyone else had a raised hand? No. Okay, go right ahead, Pat.
all right, thank you. So let's talk a little bit about what's called the interactive process. And so the reasonable accommodation process, or requesting a reasonable accommodation, that process is the interactive one. And it's a conversation, it's an interaction between the employer and the either applicant, this applies to people who are applying for jobs, or an employee. The accommodation must be effective. It can't just be pulling something out and saying, we gave this person an accommodation. It must work for the person with a disability. And if it doesn't work, then you need to keep working and discussing what will work for that person. It applies only to accommodations that reduce barriers to employment related to the person's disability. So it may be obvious, but you can't just request anything you want. It has to be related to the person's disability to make their job work for them. And it does not have to be the requested accommodation if it is effective and specific to the individual employee. So when the person is requesting accommodation or may find a few that work for them, it does not have to be the one that they requested as long as it is effective. And employers can provide an accommodation beyond what the ADA requires, of course. That is always true.
Yeah, keep that in mind generally about the ADA. You can go above and beyond.
Sure. And so what is the interactive process? It starts when the employee, applicant, or third party notifies a manager or human resources to request an accommodation. So it could be someone who knows the person, or the employee themselves, or an applicant. And if they inform HR that they want to request, then that counts. The employer and employee or applicant continues to discuss possible accommodations until an effective, reasonable accommodation can be found. So you keep going. If it's not effective, you just keep going and working at and researching a possible accommodation. The employer can request medical documentation after a conditional offer of employment is made, if it is needed to understand the accommodation request or disability. That's a lot of words, which means once a conditional offer has been made, the employer can request medical documentation if they're still not sure what the person needs as an accommodation, if that is a non-obvious disability. And both sides must act in good faith and in a timely manner. The best practice is an agreement about reasonable accommodations need to be signed by the employer, the manager, and/or human resources. Never rely on word of mouth for agreements such as these.
Signed by the
Have them
employee, the
by
manager.
the employee,
Mhm.
signed by everyone who's involved.
So it's not required under the ADA, but it's really a good practice to make sure that you have it in writing.
Correct. Okay, and there is a duty to accommodate when the person needs it. It needs to be ongoing because there are changes in the workplace that can happen, like there could be a promotion or transfer, added job duties, manager changes, or policy changes in how things are done in the workplace. And if any one of these things are going on, it may change what the accommodation is that that person needs. Changes may require an adjustment in an existing accommodation, providing an accommodation where one was not needed before, or changing an accommodation that was provided before. Okay, and now I'm going to switch it over to JJ, and we're going to talk about some scenarios. JJ?
Sure. Thank you so much. I was just writing down some questions in the chat, and I'll address them initially and then pass them around if you all want to add. I saw a comment about creativity, that sometimes it just takes an employer and or the employee to be creative with accommodation solutions. I really like that the person or the hypothetical that was presented was someone who needed to kind of move every so often, and they came up with either a pedal desk under the desk or kind of a treadmill under the desk. I think that's creative and simple solution, right? Doesn't cost a lot of money. Make sure that you have a good employee, maintaining a good employee. And that was something that I think you might have commented on, Pat, was the employer going beyond the ADA, right? The ADA doesn't prescribe exactly what an employer has to do. And so in terms of what accommodations need to be provided, it's made through that interactive process. And so an employer can go above and beyond. And I would encourage, if there's any employers on the call, to do that. I mean, again, this is a tough time to recruit and retain employees. And I think people with disabilities, employees with disabilities, if they are properly accommodated, are some of the best employees that I know I haven't had an opportunity to work with. So I'd encourage going above and beyond to really recruit and retain employees with disabilities. There was a question about federal employees being covered by the ADA. If it is a federal employer, the Rehabilitation Act of 1974 would apply to federal employees. It's actually the pre-law before the ADA came out. And so a lot of what the ADA, at least the employment provisions, came out of Rehabilitation Act type language. So if you are a federal employee, the other big difference is a lot of the timelines in terms of complaint options and those kind of things. But the protections are essentially the same. And at least for the Ninth Circuit, when you're looking for guidance, there's been some case law that says you look to the ADA if there's not a case on point from the Rehab Act. So when we're talking about the ADA, just know that is private, not federal employees. The ADA also applies to state and local government employees as well. And Jan provided a nice definition in the beginning. There was a question about specific mental health disabilities. I would say that you need to provide enough information to your employer that establishes you are a qualified person with a disability under the ADA. And then if you're asking for an accommodation, there may need to be additional information, whether it be a diagnosis or how that mental health disability substantially limits a major life activity. So I think Jan touched on this earlier, but just to reiterate, the ADA is not a disability based on diagnosis. It's a physical or mental impairment that substantially limits at least one major life activity, and then was also expanded to bodily functions in the ADA Amendment Act of 2008. So you may have to disclose a diagnosis if you have one, if it needs to be shared in order to relate to the accommodation. there's one more question, and then I'll pass it to Jan and Pat if they want to follow up on anything that I've just said. A timeline on interactive process. Obviously, this person in the chat put that June was the date of an accommodation request, and they may still be waiting. Again, without knowing more and not providing legal advice, that's a long time. I'll just give concrete advice to follow up with your employer consistently. Whoever's out there, whoever has that question, I would email your employer, put it on your calendar for like once a week, and just ask for the status. And especially if it's impacting your ability to perform the essential functions, I would include that also. So it's not just a status check, but it's also informing them that you require these accommodations to meet the essential functions. And if that's being impacted, to describe how that is being impacted. And if there is a proposed accommodation that can, I'll say easily, and again, we can all debate how easily can be defined, articulate that, right? That reiterate what you asked for, reiterate how it can be provided, reiterate where it can be purchased if it's something to be purchased or installed, etc. So give your employer, stay on your employer. June is, well, if I do my math right, about 4 months ago. So that's some time without communication, at least based on the scenario.
Yes, and there is no specific timeline, but yes, that's a long time, and you want to also document it for purposes if it's like JJ said, if it's impacting your ability to perform your essential functions, because when it comes time for your performance evaluation, you want it to be made clear that you had asked for a reasonable accommodation and that you had provided this information, and that should not impact your performance evaluation. Also, there's one. Another one that disturbed me, that somebody said, can an employer require a person with a disability to ask for an accommodation publicly and be decided by coworkers? I would say that is absolutely against what the ADA requires. It requires confidentiality. It's only really people, like maybe a manager or an HR person, somebody with a need to know, that should know about any request for an accommodation or any documentation of disability, and it should not be made public. That is against what the ADA says.
Jan, I'm wondering if we should go ahead to the scenarios and then come
Yeah.
back to some of the questions.
Yeah,
Okay.
let's move ahead to the scenario so that JJ can get some participation, although I've been pleased with the participation so far.
Yeah, no, there's been great questions. So thank you. And if you can keep putting them in the chat and we'll get to as many as we can. So I'm going to present scenarios. Hopefully that will lead to some questions. If it doesn't, we'll move either to the next scenario after describing kind of the answer. So bear with me here while I read some slides. So scenario 1 relates to assistive technology. We have an employee who's blind, uses AT or assistive technology. Their employer just installed new computers with different technology for all employees. The employer did not make sure that the blind employee could use the new technology with their assistive technology. The employer offered no training on the new technology. The questions for you are, is this employment discrimination under the ADA? And what should the employer have done?
Does anyone have a thought? Looks like I see Stephanie's hand.
Hello, Stephanie. I see you there. One moment, please. We're going to allow you to temporarily unmute. Okay, you can unmute your microphone and give your thoughts.
You. I am in Knoxville, Tennessee, and yes, I believe this is employment discrimination under the ADA. As an employer, I would have hoped they would have let all directors or heads of the group know that changes were coming. This is the new change for the technology we'll be using. Ensure that your current programs can use the technology, and if not, let's work together now to make sure we can make any adjustments. And to me, that would apply to any employee, whether or not they used a program specific to a disability such as blindness.
Thank you, Stephanie. And I'll say it depends, because I don't want to say every, depending on the scenario, they should have done exactly what you've said. It could constitute disability-based discrimination if they then upon notice, which you would hope they wouldn't need notice and have done what Stephanie had said, which I think is the right way to go about installing new software, period. But if they didn't and they got this employee contacted the employer and said, my JAWS technology no longer works, or this software does no longer works, that they get on it right away and fix it. And again, so there's not a lot of interruption. In a scenario similar to this, I assisted someone where there was a delay in that process, which then impacted their production. And then unfortunately, the employer kind of compounded the issue by then saying they were not meeting the quotas for their job. And obviously, they were not going to meet the quotas if they did not have functional software that worked for their blindness. So my scenario was probably closer to discrimination. There's a correct way, and I think Stephanie noted on, if you are going to roll out, never assume that new technology is better, and never assume new technology works with someone else's technology. I think we've got in this state, and again, I've dated myself already. I've been working in the field for 24 years. The technology advances are extremely different, extremely better in some respects, but there are some technologies that work for a person with a disability that requires they have an older version of Windows or have an older computer that's already pre-set up or preset with their settings to navigate. So it doesn't always equal access if you say, well, I provided you a new computer. So thank you for that. And Stephanie, you answered the second question, I think perfect, of what the employer should have done. So thank you. I know there's a lot of questions flying around in the chat. I'm going to try to get to one more scenario, and then we'll try to ask some additional questions. So scenario 2 is about effective communication. A new employee who is deaf works for an employer who requires watching videos and computer-based learning during training and orientation. This employer agrees to place captions and American Sign Language onto the videos and learning modules. Did the employer make a reasonable accommodation for the deaf employee? Is this likely to be an effective accommodation? Yes and yes, Sandra commented in there. Anybody else want to add to that? I can expand on the yes and yes. I see some more yeses. Again, I'm a lawyer, so I'm going to say it depends. You know, the scenario again, and someone who's deaf varies, but I think in this scenario it could effectively accommodate two scenarios that I've encountered. I've encountered someone who was born deaf, first primary language was American Sign Language. So providing American Sign Language on the screen on these computer-based learning modules probably is effective based on if their primary language and they were fluent in ASL, they check the box in terms of having ASL on the screen. I've also represented people who were later deafened in life, and so the ASL would not be effective because they did not learn ASL or they're still learning ASL. But this scenario gives you that they provided captions as well. So I think they would be accommodating that person who might be later deafened in life as well. So I do think the short answer is yes and yes, but the highlight that I would want to highlight for this scenario is always ask, because one's disability, although it might be the same diagnosis, you know, maybe you have two employees who are deaf, the accommodation needs are not always the same. And that's why it's always important to engage in that interactive process to learn of what accommodations your employee needs, even if you've previously worked with someone with the same diagnoses. So Pat and Jan, do we want to, I know they've been flying still in the chat. This is great.
There's a lot of great questions. One that I wondered about is, so I understand that being moved to a different position is a last resort, but can an employer tell you they wouldn't consider that accommodation until you've exhausted all your available leave, which I think pregnancy, family medical leave, FMLA, and ADA?
So
what do you think, JJ?
Well, I mean, if it's talking about a reassignment, reassignment has the terminology of the accommodation of last resort. And so I can, if this is what the employer might have said, I can read between the lines and it sounds like they are trying to exhaust everything else. I don't think going out on leave is an accommodation. I do think that's more of a go out on leave. Like if you're saying I can do this other job, it's open, I'm qualified for it, that's where the reassignment or the accommodation of last resort, as it's sometimes referred to, comes into play. Talking about leave and those things, unless that's what might be needed, but I'm not hearing that when someone asks for a reassignment. I'm hearing, or traditionally what I've heard through the years is, I can't do my job anymore, but I can do this job, and that could be with or without accommodations. The risky thing there, and the advice that I've given many clients is, when you put yourself out there and say that, then you might not have any alternatives, because you've essentially said, I can't do my job over here. And you can phrase it different if you wanted to, but that's what sometimes employers hear. So I do think, an employer can ask you to consider other accommodations. Obviously, considering is not agreeing to, and you might want to try them too, just to preserve your employment. But if there's no way and no accommodations that will allow you to do your current job, that's when I've advised clients to go to reassignment.
Great. Great. And then I'm seeing a different question about if an emotional support dog is not fully trained and is prone to run away is there precedence for requiring the animal to be confined to a cage? And I think the answer to this really, I mean, you can have an emotional support dog in the workplace as an accommodation if you go through the interactive process and if it is not an undue hardship for the employer. But if the animal is not under control and is disruptive to the workplace, I think there is an argument possibly to be made that the employer could say that that is then an undue hardship. And I don't know whether or not you would keep it on site in a kennel if just being present helps the employee. So you would keep it there. But there certainly there certainly is a way that the employer can say it's an undue hardship if it is causing disruption in the office. So you may need to work out some kind of different way of being able to have the emotional support animal if that's what's needed for the employee.
I wouldn't disagree with any of that, and agree. I mean, I think there are obviously the accommodation part, and then also if the animal, the emotional support animal is not able to be controlled, that could lead to the undue hardship and a request for. And if they're requesting either a kennel or some type of a cage, I mean, maybe that is a intermediate step while you're still training your emotional support animal, and that if it is effective to still just have them present. Again, you have to evaluate the need for the emotional support animal, how you use it related to your disability. And so if it's caged or kenneled, is that still providing you the accommodation you need? If it's not, then, additional training and other things probably are the step to allow you. And then maybe there's an intermediate accommodation that can allow you to, work from home. Maybe there's a leave option, if you need that to train. So there's a lot of things there but I think they could require or at least make the argument it's an undue hardship.
And then it looks like I see Gina raise their hand.
Okay.
Gina?
I don't see
I
a
think,
raised hand in the.
no.
Well, it's gone. Oh, now it
Oh,
is
there we
again.
are. Hello, Gina. I see you there. One moment, please, and I will allow you to unmute yourself. Okay, you can unmute yourself and ask your question.
I'm just a little confused why a emotional support animal, which is not a service dog, would be even considered a reasonable accommodation when they have no access rights. And by definition, a service animal must be under control, and they can't be one that is not. I can't even think of the right word. It uses a toilet in the building instead of going outside. They have to be task trained, and an emotional support animal only has housing rights, not work rights.
Well, it's interesting because I think what you're speaking about is generally when you're looking at Title II for state and local governments or Title III for public accommodations like businesses and nonprofits open to the public, that's true that that's really service animals that are allowed, and typically emotional support animals are allowed in housing situations. But the employment part of the ADA is different in that it really is just kind of the interactive process is kind of like a contract between the employee and the employer. So if you can work it out to bring an emotional support animal to work and it doesn't cause an undue hardship for the workplace, for the other employees, for the employer, then that is something that you can arrive at as a reasonable accommodation through the interactive process. It does not have to be a service animal, but it cannot be disruptive to the workplace. The animal, does need to be, housebroken. The person needs to be caring for the animal properly, during the work time. And so all of that. But you can, in ADA Title I, have an emotional support animal as an accommodation, as opposed to the other parts of the ADA where it really is only service animals that are allowed.
I could see that abuse very quickly, but I just know there was a case that a student nurse wanted to bring their service dog, which they said was for their anxiety, and caused allergies, and it was considered an undue hardship because they couldn't rearrange all the floors like she wanted. And the case went into extensive detail how the hospital attempted to accommodate the student. The student lost the case because she was fine without it, but and explained how these nurses are the only ones trained in the specific procedure, and they can't rearrange the entire facility when two people ended up with hives and had to go home, ended up in employee health because it was that much of a disruption.
Okay.
But so it's just like, I guess I know, I'm just so used to the service animal and the abuse of the title by so many people, especially around where I live, that it gets out of control really quickly.
Yeah, that's true. But everything depends on the ADA, and it's a very individualized discussion, including in employment. So JJ, should we try to do one
Yeah,
more scenario?
let's do one more, and then I know there's some questions. So this is something regarding a workstation accessibility. So an employee who is quadriplegic requires an accessible workspace and access to their computer. Their employer hires an access specialist to identify possible accommodations. The specialist notes that many of the changes that the employee would require are simple and low cost, such as raising their desk, mounting the computer screen on a platform, and buying inexpensive software to utilize the keyboard and the mouse. Should the employer make sure these accommodations are effective for the employee? And what other accommodations might have been simple and low cost? So Susan Allen, I think, is answering the first one. So should the employer make sure the accommodation is effective? Yes, that's the simple one. Thank you. That's a good answer. I hear a yes to one. Is Gina responding on two as well? Let me see. Okay. Thank you. Got a new message. Ask the employee what they need for two. Yeah, you most definitely can do that. I mean, obviously, if you bring in a specialist, that doesn't mean that's what the person may need or what's effective for them. We have, let's see, restroom modification. Obviously, having access to a restroom is needed. So if that's something that the employer provides, then most definitely. Voice activated computer apps is another one, another possibility if that works.
Yes. So these are all good possibilities.
Exactly. Somebody even put remote work, which could be a reasonable accommodation as well. So I think the point here, kind of going back to Pat's discussion of the interactive process, is although you brought in a person who's a specialist, you always want to still involve the person. And even if they come up with a list, see if that's effective, see if they need anything else. We've had employees who simply brought in, or suggested we just raise it with some cinder blocks. Obviously you want safety, but that was a solution they articulated. One person preferred to use mouth sticks to use to navigate their computer, something again that they had used and had accommodated themselves for years. And so again, also not taking anything away that someone might want to use. I mean, it doesn't have to necessarily fit, what a report says or what you think is appropriate. As long as it's effective is always the goal. So I'll stop there. And then do we want to kind of screen through some of those questions and answer a few more while we have a few minutes?
Yeah, and I know there are some slides at the end, but we have talked kind of about undue hardship and what that might be for an employer, which is on the slides that follow the scenario. And so, you know, when it might be an undue hardship, and I know Pat was going to go through these, but really it's just a matter of, again, it's a case by case basis about whether it's an undue hardship, and the employer really needs to be specific about why something is an undue hardship.
And direct threat.
Yeah,
Jan,
and then
go
yeah,
ahead.
go ahead.
So no accommodation is needed when an employee or the requested accommodation poses a direct threat. That which is defined as a significant risk of substantial harm to the health or safety of the employee or others that cannot be eliminated or reduced by a reasonable accommodation. And what's important is that it must be based on reasonable medical judgment, the most current medical knowledge, and on the best objective evidence available. And of course, always on a case by case basis. So I think we can go ahead with questions. Yeah.
Yeah,
Go
and
ahead.
you will have these slides available to you,
Yeah. Yeah.
including for the resources that we have given you as well. And one question that I did want to make sure we addressed is, do employers have to accommodate if the functional limitation is continuing? And I would say, you know, yes. I mean, the functional limitation continuing, um, you know, just means that they still have, you know, the functional limitation, and that means they're going to continue to need the accommodation. Now, whether it will change over time, they have to look at that, but absolutely the employer has the obligation, if the functional limitation is continuing. It's not just meant for people who have, you know, temporary disabilities. Okay. And were there any other questions that you saw, JJ, that
Let me look through.
lots of people answered the scenarios, which we really appreciate. Thank you.
Yeah, there was a question way back to ask whether temporary employees are covered under the.
Yeah, that's a good question. I saw that one. Well, actually, I didn't see the temporary. I saw the volunteer.
Right.
I'll address the volunteer. So Title One, in my review, it does not apply. Title One of the ADA does not apply to volunteers, but I'd look to Title Two or Title Three as a program or service as a mechanism to request reasonable accommodations or assistance to participate in that program or service, that volunteer program. So Title II, again, governmental entities, Title III, private programs. So depending on the scenario that applies, it would be Title II or Title III. And then in terms of temporary, temporary employees, I think you have the hours required, right, Jan? You had that in a slide, if I remember correctly.
It was 20 hours, Jen?
Yeah, at least 20 hours, in a 20 weeks, sorry.
Sorry.
Any number of hours on 20 weeks in a calendar year. Yes. Yes, so temporary employees can be covered.
The one that I wanted to address, I think it was by Paula Fitton, regarding medical personnel answering questions, determining whether one qualifies for a reasonable accommodation.
Yeah.
I'll broadly say, and if there's any medical professionals on the call, thank you for attending, because I'm sure you're learning a lot. But medical professionals are not trained in the Americans with Disabilities Act. Disability is foreign, except for maybe like Social Security disability, which is very different than an ADA analysis. So I wish they had more training about the ADA, because it will help keep people employed or obtain accommodation. What I would do, best practice, at least in my view, is to draft the letter and the accommodation needs and the disability, have them review it, add it, obviously make it their own if they need to. But two reasons. One, first, like I said, they don't have a lot of training. And then two, they don't have a lot of time. I mean, what's the last time we had more than a 15-minute doctor's appointment after waiting an hour? So do the work for them. There's a lot of sample accommodation letters. The Job Accommodation Network is a great resource where you can look at different things to help your doctor understand, and then be willing to provide whatever they need. Some doctors I know ask for a job description, those kind of things. But just make sure they're understanding the purpose that they're writing this for is accommodations, not to qualify you for a benefit or a service, because I have had a few examples where a doctor writes it more as a Social Security eligibility letter, and then the employer turns that into, oh, you're not qualified for the job any longer. So we want to make sure your doctors know the purpose. So it is a struggle. It's not something I've heard of it multiple times. So just help your doctor as much as you can.
Okay, JJ and Jan,
Yes.
we are out of time. So Jan, do you want to close out?
Yes, well, thank you all for coming today. We really appreciate all the questions and participation for the scenarios. We really appreciate JJ and Pat for presenting today. Thank you to our interpreter Sharon and our captioner Dana. And we hope you all will join us for the next Lunch and Learn webinar. And stay in touch with us as you see the information on this slide. And please complete your evaluations. There was a link in the chat for that. Thank you.
All right. Thank you all.
Thank you.
Thank you so much.